Good afternoon, everyone, and welcome to this joint webinar by Walker Morris and Smith Williamson, now rebranded Evelyn Partners. My name is Gwendolyn Davis, and I head Walker Morris's Commercial Disputes Resolution team, and I will be chairing today's webinar. Accompanying me today are Rebecca Jackson and Jack Heward, who are both senior associates in my team. The three of us have worked on numerous cases in this area of law, from advising on the enforceability of restrictive covenants, drafting appropriate undertakings where there has been a breach or suspected breach of restricted covenants or confidentiality provisions, to seeking injunctive relief where appropriate. We are joined by John Holden, who leads the Forensic Services team at Evelyn Partners. John began working in the field of computer forensics whilst working as a detective in the fraud unit of the Cheshire Constabulary, and has extensive experience and specialises in all manner of forensic computer investigations, including data capture, corporate litigation support, and fraud and money laundering investigations. So what has prompted this webinar? We've seen an increase in instances and instructions from clients wanting to pursue ex-employees who've taken confidential information and or who have flouted restricted covenants in their employment contracts. This is perhaps as a result of changes in working patterns and the perception that employees are not being monitored to the extent that they previously were in an office environment. There have also been improvements in technology and other effects arising from the COVID-19 pandemic. More generally, for example, an increase in job opportunities and less geographical restrictions. There have also been a number of key cases in this area. For example, the Court of Appeal decision in Trailfinders Limited against Travel Counsellors Limited. That case gives an original employer stronger grounds to take action, not only against former employees, but also against the new employer. You can find a briefing by Rebecca on the details of that case on our website. Where there has been a breach or a suspected breach of confidentiality by an employee or ex-employee, it is important that employers are able to act quickly and decisively to best protect their confidential information and their legal position. It is critical for an employer to know how to practically establish whether an employee they suspect of taking confidential information has done so, and what legal steps and remedies are available to the business. This webinar is part of a series of webinars we are producing in this area. The last in the series dealt with an overview of the legal process in this type of case, from letter before action and investigation through to injunctive proceedings. There is a link to that webinar which can be found on our website. However, we focused this webinar on that secondary stage in the process, that is, the investigation and the practical steps required to firstly establish whether any confidential information has been taken, and if so, what information. Also, how can an employer carry out an effective investigation, ensuring that any evidence obtained is admissible in court? This is critical because employers need to ensure that things are done correctly from the outset in the event that you're required to commence court proceedings at a later date. With that in mind, we'll finish by discussing what information an employer will need before considering whether to take further action seeking injunctive relief, restraining the employer from using any confidential information that has been taken. We will consider what the threshold tests are in order to successfully obtain an injunction, and what elements of the investigation might affect your prospects of success in obtaining that relief. If you have any questions on any of the areas we discussed today, or more generally in relation to this area of law, please feel free to raise them via the chat function or to follow up by email, and either ourselves or John will be happy to answer them. Our slides and a recording of this webinar will be available on both Walker Morris's and Evelyn Partners websites afterwards. So at this point, I will hand over to John to consider what practical steps can be taken when an employer initially suspects that an employee has taken confidential information. John, can you provide us with your input regarding what factors you would be considering at the outset of an investigation?
Yes, thanks very much, Gwen, and good afternoon. I suppose the first point to mention is that certainly from my side of the fence on the investigation, we're led by the client. Many of the sensitivities in these types of cases, they vary from each case to the next, and many are different from each other. And so we always remember that the clients are in control. I suppose one of the biggest sensitivities would be whether or not the employee under investigation is still in the business, or whether they are now outside to some extent, either on gardening leave or maybe they've left already. A major consideration for us is the preservation of evidence. It's vital that certainly once me and my team are involved, that the chain of continuity of that evidence is kept intact. By the nature of an investigation, we don't know what we're going to find and how important and relevant that information is going to be. So everything that the forensic investigator will do is in compliance with the Association of Chief Police Officers guidelines for the handling of evidence, of electronic evidence, so that it can be used at whatever tribunal comes up in the future. There is always a balance at the start of an investigation between the needs of the employer to fully understand whether or not there is sufficient evidence to back their suspicions, and then to instruct outside legal teams and somebody like us. So there is always a degree of internal investigation that has to go on at the start. And that's fine and that's normal. But obviously that investigation for many businesses won't be done in a forensically sound fashion. That doesn't mean to say that the evidence that's collected is inadmissible, but you need to get to the point where you are happy that there is a requirement for further investigation, that at that point there is a hands-off policy. Computers aren't touched any further, for example, and I'll come on to why a little later. And then you instruct the experts. So the next thing to think about, once you've decided that it's time to instruct external expertise, is to think about how they're going to do it. Especially if the employee is still in the business, you might wish to collect the evidence in a covert way. This makes things more tricky, but there are usually very good reasons for doing that. And sometimes even if the employee has left, you might want to consider the effects on their colleagues, to see somebody like me and my team coming in, rummaging around in their previous colleague's desk, etc. That might be unnerving, and you might want to avoid that. And there are ways that we can collect information covertly, from things like accessing the system direct from the central server, using the internal IT department to facilitate that, to things as simple as just coming in out of hours when everybody else is at home, or at weekends, or what have you. The preservation of data from mobile phones is more tricky because usually the employee will keep that on them. In the past, we've done things like done full telephone recalls for entire teams as a bit of a smoke screen, to try and get the employee's phone so that we can look at it and see whether there's any additional information there. Obviously, if they are now out of the business and we have that telephone, then that requirement isn't there. One of the first things that is essential and you can do in a real hands-off approach is to preserve the server logs and email information that is held centrally. Server logs are particularly dynamic in that they will usually be overwritten after a few days. Depending on how your IT is set up, that might be a day or two, it might be a month or so. But as each day goes past, you will potentially be losing information that might be useful for you if you don't collect those server logs. And as I say, that can be done centrally without any knowledge of the user. If you're using Office 365, and many businesses do now, one of the advantages of using Office 365 is that you don't need to have any sort of backup regime anymore. So the days of us going into the IT department and collecting backup tapes and things like that are becoming less and less. Of course, with that comes a problem in that where we used to be able to easily go back several months, if not years, for email data, we will be limited to whatever is held in Office 365. And again, some of that data is dynamic. So typically with Office 365, unless you've configured it differently, you can usually go back to 40 days previous of email activity quite easily and to preserve that in the event of some investigation. But obviously, as each day goes by, that 40 days rolls forward. So you run the risk of losing that important information. Quite sensitive, but consider a desk search. I would always recommend that if sensitivities allow, and if they don't, then perhaps do it out of hours when the colleagues aren't around. There's very often important information held there, certainly things like old passwords that might be useful for us to use as a password base for our password recovery activities. Once you've told the employee or the employee is aware that there's an investigation, it's vital that all their access should be shut down. That especially includes remote networking, so access from home, access to information via mobile phones. It's very, very important that that's locked down, even if at this point the exit is some sort of semi-friendly exit. I would always advocate that. I'll give you a story a little bit later about when that didn't happen and the things that went wrong. Consider asking for the return of any company-owned storage devices, obviously mobile phones, but things like the USB devices and those types of storage. And I suppose one of the key points to say is that, as I said at the start, the employer is in control. There is sometimes an assumption that once experts like myself and my team are instructed, that there is a requirement to go all in and be along for this ride that they have very little control over. And that really isn't the case. We will always advocate an investigation that goes on a staged basis. So the first step is to see, okay, can we maybe put some meat on the bones of the suspicions that have happened so far? And then what can we do in a cost appropriate way to go to the next step to see, well, if this particular activity has happened, let's see if something else has happened and whether or not it's worth looking at that. So you don't have to go all in right at the start. We can do it in a phased basis. And with that, we will always work closely with our instructing solicitors. It's important that the legal and IT teams work as a unit on the electronic data side of the investigation. It brings better results and focused costs.
Thank you, John. Whilst we were talking, actually, there's a question that's come in on the chat. In reality, how easy is it to recover deleted information?
Okay, yeah, that's a good one. It's a common one. Obviously, the recovery of deleted information is something that we do all the time. But I'm afraid the answer to that is it depends how easy it is. The way that electronic data is stored on devices, I always try and liken it to a book. At the start of a book, you will have an index of chapters, and chapter 8 might start on page 58 and run to page 70. When data is deleted, all the system does is to remove the entry in that index. It doesn't actually write over the data. So all it basically says, once you've deleted that document, pretend it's a chapter, it says if you need to, you can reuse and wipe over the information that's held at pages 58 to 70. The sooner you collect a piece of electronic data and interact with it as little as possible, the more chance you have of recovering data that was recovered previously. So very often we will find lots and lots of deleted information that's absolutely relevant. Even if data has been wiped using disk wiping tools that mean that the recovery of data is impossible, we can usually find, at the very least, evidence that anti-forensics tools have been used, and that in itself is good evidence to warrant some further investigation potentially.
Thank you, John. That was very interesting. So whilst John has covered the practical considerations at this initial stage, an employer will also need to think about the legal implications of an investigation of this nature. So Rebecca, from a legal aspect, what should an employer bear in mind at this first stage of an investigation?
Thanks, Gwen. So, of course, there's a number of legal considerations which are going to depend on the particular facts. But I think the first thing to mention, John's touched on it, is the fact that there's a distinction between an individual that's still employed by the employer and one whose employment contract is already terminated. So if the employee is still employed, then the terms of the employment contract and any applicable company policies are still likely to be binding, as are the implied terms which would apply, such as the implied term of mutual trust and confidence and the duty of fidelity. So the implication of that in the context of an investigation is that you're likely to need to ensure that the investigation takes account of those obligations, of course. So this means that the investigation needs to be proportionate and in line with the company policy and procedures, which are hopefully in place. If the employer goes in overly aggressively in its investigation, then it could leave itself exposed to a claim for wrongful or constructive dismissal where the employee is still employed. If there's a breach by an employer of the employment contract, then that would undermine its ability to enforce restrictive covenants as well against the ex-employee, even after termination of the employment contract. So what this means is that the employer needs to be able to justify the extent of the investigation it's undertaken. The test there is that there's a reasonable and proper cause for the investigation. It's also worth considering whether there's conduct which is calculated or likely to destroy or seriously damage trust and confidence, so that implied obligation. And more generally at this stage, you might want to think about, if the employee is still employed, whether you need to terminate the employment contract, suspend the employee, put them on gardening leave, go through a disciplinary process. And it may be that you need input from a specialist employment lawyer at that stage. The next absolutely key consideration from a legal perspective is the definition of confidential. So is the information that you're concerned about in fact confidential, and how are you going to demonstrate that to the court should that become necessary at the stage that Jack will come on to? have employees been trained about what constitutes confidential information, and is that clearly defined in the employment contract? And has the employee been referred to policies or procedures? So it might be an acceptable use policy, for instance. I think what I'm saying here really is that you need to make sure that your expectations as an employer are made clear from the outset. So in the Trailfinders case that Gwen's already mentioned, important factors in that finding were that the information was stored on a password protected Trailfinders system to which only Trailfinders employees had access. And also it was determined that the information in question was the kind of information which would be valuable to any travel business. And a suggestion that the information was not sufficiently protected from public disclosure to be the subject of a breach of confidence action was rejected by the court. So even though Trailfinder system might not have been as rigorous as it ought to have been, there had been an attempt on the part of the company to limit access, which was important in that finding. So you should be thinking now about how you control access to information within your businesses. Do you password protect information that you deem to be confidential? Do you limit who has access? Are things marked as confidential? And very importantly is whether or not it's easy to differentiate between confidential and non-confidential information. So do you save that information in different areas, for instance? And when you've got new incoming employees, it would be useful to have an induction process which sets out your expectations and what you deem to be confidential information at that stage. In terms of the new employer, so ex-employee is moving on to new employer, what about when they receive confidential information? So you might want to bring proceedings against that new employer, again for reasons Jack will come on to. But what's the position in terms of their understanding of what constitutes confidential information? So whether or not the recipient of confidential information should have known it was confidential is determined by a reasonable person in the recipient's position. So it's an objective test. However, the Court of Appeal in the Trailfinders case concluded that it's not essential that the defendant knew the information was confidential or intentionally turned a blind eye to whether the information was confidential. The lack of any reasonable inquiries may be sufficient to breach the equitable duty of confidence. The court said in that case that the new employer, which was travel counsellors, that they must have appreciated that the information given to it was likely to be confidential, or should have at least made inquiries to find out if the information was indeed confidential. So what this might mean to your businesses is that if an employee is joining your business from a competitor or otherwise for that matter, you need to be cautious if they appear to have more information than they could possibly have remembered. So that might be an excess of client information or product pricing, design details, ingredients or component lists, that type of thing. Because if you know or ought to have known that such information would fairly or reasonably be regarded as confidential, there will be a duty of confidence imposed on you, even though there's no contractual relationship between you and the original employer. So good starting point is obviously to think, well, would you treat the relevant information as confidential if it belongs to your business? You might want to think about the particular industry that you work in, because commercial usage and practices can be relevant when the court's considering whether information should be deemed to be confidential. And it's not necessarily about the complexity or bulk of information that the employee's taken. It's also just worth mentioning at this stage that the cause of action for breach of confidence, it doesn't flow from a proprietary right. It's rather a right to prevent transmission of the information and to protect the secrecy of that information. So without getting too bogged down in the legal makeup of this type of claim, it's not only about demonstrating that the information has the necessary quality of confidence, but also that it was imparted in a manner which imposed an obligation of confidence, so that might be an employment relationship, and there was an unauthorised use of the information to the detriment of the owner, which is John's role really to demonstrate that there's been unauthorised use. If the relevant employee has left your business and you're relying on post-termination provisions or restrictive covenants in an employment contract, then you need to be demonstrating that the provisions are necessary to protect a legitimate business interest and that they're enforceable. And we we've already produced another webinar on those intricacies, which Gwen's already referred you to. Another key consideration which always crops up is data protection. So if the employer is sharing information which is personal data or personal sensitive data of the employee during the investigation, then the employer could face a data protection claim. So whilst the employer might need to take a detailed log of its investigation, which might include personal data, that information should be kept confidential and should be shared only with those involved with the investigation, as opposed to more widely shared. But more commonly, what information has the employee taken? And could that be a breach of data protection legislation in itself? It might include, for instance, personal sensitive data of customers. And off the back of that, you could then be in a breach of regulations or laws. So do you require, is it a requirement that you report that breach to the ICO or the affected customer? There's also a broader consideration in terms of reputational risk to your business. So you might want to think about specialist public relations advice. You might need to think about internal or external statements that need to be made, or issuing management instructions as to how to deal with circumstances like this in the future. The other point, because I specialise in defamation claims, I'm always thinking about that angle. So if other employees get wind of the investigation and post negative information regarding the relevant employee online, could that create a potential defamation angle, particularly if the investigation hasn't concluded? Because we've seen instances where employees, other employees, not the relevant employee, but they've jumped to their own conclusions because they've become aware of an investigation and then posted things about the employee that are untrue online. And conversely, what is the employee or colleagues of the employee saying regarding you as the employer online? And could this cause your business any loss or damage? So it's all things that you should be thinking about, looking into, and then recording, you know, potentially as easy as taking screenshots of a social media profile. Another very legal consideration is privilege, unfortunately. So whether or not a communication or document might be deemed to be privileged is not necessarily straightforward, and it's probably something you would want to take the advice of a lawyer on. But the involvement of a law firm or a lawyer from the outset of an investigation not only ensures that the investigation is legal and that you can come up with a wider strategy, but also it should ensure that various communications and documents will remain protected and that they will attract privilege. So the idea of that is that they won't be read or relied on, disclosed by to the other side during court proceedings. So really the message there is that you need to be limiting who communications regarding the investigation and strategy are shared with, and hopefully approaching a lawyer to ensure that they can advise you about privilege. I've already mentioned the importance of logging the investigation and any losses that are flowing from this breach or potential breach, but you need to be thinking about how you quantify and evidence that loss or damage to the business. And that can be quite difficult, but like I say, keeping a careful log and giving that some thought from the outset can be really helpful in terms of evidencing it. And you also have an obligation to mitigate your losses. So consider damage control. How can you limit this loss? And take a log of all associated costs, including the management time that you're spending on this investigation. So I'm not going to bore you with every civil procedure rule that you might need to consider, because we would definitely be here all day, but it's just worth mentioning briefly CPR compliance. So if you're drafting a letter before action or taking witness statements that you might later want to rely on for the purposes of court proceedings, you'll need to ensure that you're complying with civil procedure rules and relevant protocols. But hopefully, if you've got a lawyer involved, they will be advising you on that. Another thing that we often get asked about is employee monitoring, particularly more recently since the pandemic. And we've produced an entire webinar on that topic. That was given by the head of our tech team, Sally Muez, and our regulatory and employment team. But it's just worth mentioning there's no absolute prohibition on against monitoring employees, but there's a lot of legal considerations there. including privacy issues and again, the need for the employer to be proportionate. So is the monitoring protecting a legitimate business interest, and how can that be weighed up against the employee's right to privacy and the data protection issues that we've already mentioned? It's important that if you're going to monitor, that it's referred to in policies and that there's a privacy notice in place explaining how the employer will process and collect information regarding the employee. So it's not just about the employment contract, which is what a lot of our clients have kind of contacted us about. And if you're looking at new innovative technology or tracking employee behaviours, there are likely to be a number of considerations, including regulatory issues. So you would need to think about whether you might need to undertake a data protection impact assessment. So there's further compliance hurdles there. And then just to sum up, really, I think the overarching issue, which the courts are always mindful of, is the human rights issue that can crop up in the context of an investigation. So, for instance, what if the employee has been using a personal phone and that personal phone contains the information that you're interested in? Or even, more and more commonly, we're seeing that people are using work devices, but then also they might have their own personal emails, photographs on there. So John's going to come on to how this needs to be considered carefully in the context of search orders, but it's just worth flagging that the courts are conscious to ensure that the human right to privacy is preserved. And again, it's a balancing exercise so that you still ensure that you're able to retrieve information that could support any claim.
So Rebecca, I have a practical question for you.
Okay.
So should an employer ever directly ask the employee in the first instance why they've taken the confidential information? Because surely that will give them the answer. And so what's the harm in doing that?
So, I think from John's perspective, he's obviously said that sometimes it's better to be covert in your investigation, but these things need to be considered on a case-by-case basis, and you might need a better understanding of the technology capabilities of the companies or the policy and procedures that are in place regarding how the investigation should be dealt with. But there are scenarios that we've seen where, simply asking the employee a couple of questions might close the whole investigation down. There might be a straightforward explanation. So we had a situation where a client came to us, felt very aggrieved, very passionate about a situation, instructed us to run off to court and obtain a without notice injunction because an employee had allegedly taken confidential information, which obviously as a litigator, that's great, that was music to my ears. But actually, when we took stock of the situation, and we looked at the limited information that the employee seemed to have, we decided that we were going to take a witness statement from the employee's line manager. It's worth just saying in that case, it was detailed client details that had been printed off, and there was evidence that had happened. But yeah, after making inquiries with the line manager, it turned out that the line manager had actually instructed the employee to print off that information, and it was just purely for the purposes of a holiday handover note. So it was as simple as that, and there could have been a lot of wasted time and costs had we just followed that instruction without maybe just making that initial inquiry. It obviously does depend on the facts.
Okay, thanks, Rebecca. So, John, taking into account Rebecca's comments, how does this play out during the course of an investigation? How do you ensure that what you do remains proportionate, for example? And what happens when the employer's suspicions actually do appear to be legitimate? So, can you tell us a bit about, what happens next?
Yeah, well, I think it's right to say that my view is a little skewed in that by the time we're instructed, it's more usual than not that there is significant evidence to show that a further investigation is required, and usually that goes on to more action. That's not to say it's all the time, and this chimes with something that Rebecca said about reputational risk. Very often it's best to tread as softly as appropriate, right at the very start at least, to avoid any sort of reputational risk. There are several cases that we've been instructed on that at first, as you know, Rebecca said, regarding the document that was sent outside of the business, where what looks suspicious at first, with a little bit of digging, either reveals that there is a reasonable excuse, or in actual fact that there isn't anything further that we can do to provide any more evidence. And either way, that is good information for the client, who can then say, well, at this point, we've gone as far as we can, and either we're absolutely satisfied that there's been no wrongdoing, or that there is no merit, certainly from the forensic IT side, in terms of taking it any further. That said, it's, as I say, it's usual that by the time we're instructed, in any case, there is some meat to go on those bones already. And I would say, you might be surprised as an ex-policeman saying this, I would say once the gloves are off, they really should be off. Once you've seen the start of improper behaviour by an employee in terms of your IT intellectual property, then you really need to look at all the options that are available to you. Speed is of an essence very often, and the depth of an inquiry you need to really have a good understanding of what you can do and how quickly you can do that. So let's consider a scenario now where we have enough evidence to go and we want to press on. As I mentioned previously, we can recover deleted data, we can find all sorts of artifacts of actions, certainly from a PC and a mobile phone. We can help interpret the logs from servers and actions that have been taken on servers. And we can help, again, in conjunction with the legal team, to suggest ways that the investigation can go forward in an appropriate way, and what would be useful straight away, as opposed to what might be worth doing at a later stage, if all the elements of the investigation align. I can give you some examples of the ways that clients have responded. One example is a good way, it turns out, that I thought was going to be particularly excessive and aggressive. And then another scenario where, despite our advice, the client didn't act aggressively enough. The first one was a financial services business, quite a small one. And all that had happened, the only cause for concern was that one of a team of 9 had resigned and was going to leave and go to a competitor. Because of the nature of this business, this was a real concern for the owner of the business. And they wanted us not just to carry out an investigation on the person who's left, but also to look at his colleagues who were also in the same team. Rebecca mentioned about the acceptable use policy for the use of the IT equipment, and this allowed us to do this type of work. I thought this was quite excessive, if I'm honest, and I said that to the client, but he was happy for us to continue. We did an investigation in a covert manner initially for 9 of his team, and found quite quickly that, sure enough, they were using the company email to talk to each other and plan a staged exit for the entire team. not just the fee earners in that team, but also all the support staff as well. This was going to be a major deal for the business. Fortunately, we'd also taken the mobile phones from these people on the pretext of an upgrade that was coming, and took copies of those phones before handing them back. The investigation of the email on the computer systems revealed emails that were laying out their plans in stunning detail. The clever one amongst the group, and I use that word in inverted commas, then on an email, which we recovered, said, we need to stop using email because these may well be recoverable. Let's use text function on our mobile phones. Mobile phones that were, of course, owned by the business and that we'd subsequently got into our possession, and so the plot continued. So that was a very good result for our client, despite my misgivings at the start. The flip side of that is a case where an extremely senior person in this, a large organisation, was due to meet with the owner of the business and in effect be let go. I won't talk about the legalities of that because it's not my field, but suffice to say, this is what was going to happen. My advice was to make sure that the, we'll call him an employee, when he attended that meeting, to make sure that he brought all his devices, his laptop and his mobile phone at the very least. Our client didn't want to particularly push this at this time because this was a friendly exit. It's just that the business was moving in a different direction, etc., whatever the reason was. And unfortunately, when the meeting happened, the employee didn't have his phone with him, and his laptop, he said, was at home, which was about 40 minutes drive away. The meeting ended at 5 p.m. and we were able to show subsequently, when he handed his laptop in the following Monday, that at 5 minutes past 5, he'd started deleting data. And in effect, what he'd done, he'd left the meeting and gone to his car where his laptop was and immediately logged onto the systems and started deleting data from it. This was bad enough, but more than that, we also saw that over the weekend he installed anti-forensic software and tried, without success, to cover his tracks for the actions that he'd taken. And this moved the investigation to a whole new level because what started off as a friendly exit turned into a major investigation that could have been avoided. So there's a couple of examples of where different approaches for different cases can bring dividends.
Thank you, John. The latter story resonates with me, and it is so important to ensure that any piece of equipment that belongs to the company is given or is required to be delivered up when an employee is leaving the business. So, Jack, once the first two stages have been completed and the employer has clear evidence that confidential information has actually been taken, then before starting formal court proceedings, what are the next steps that an employer should do?
Thanks, Gwen. So if there's good evidence from the investigation that confidential information has actually been taken, and you suspect that it's likely the employee is not going to immediately destroy or share that confidential information if they're put on notice, then the first step would be to write to the employee and request undertakings from them that they're going to deliver up that confidential information and destroy any copies of it that they have. If the employee refuses to give that those undertakings, then it's probably going to be a good indication that further action is required by applying to court for an interim on notice injunction. And I think it's important to bear in mind at this stage that the undertakings that have been requested should probably be in the same or very similar terms to what you're ultimately going to request from the court if you do proceed to an interim injunction. So you're going to want to be careful not to request undertakings that go beyond what are in the employee's obligations under the employment contract, or what you would expect the court to actually grant. That's often something that's typically requested of us because emotions are very high at that early stage. So there's a need to sort of rein in an expectation of what can sort of sensibly be achieved. So at the same time, if you're aware that there is a new employer, then a letter can also be written to them, and that's going to put them on notice of the employee's restrictive covenants. And then once they are on notice, it's going to open up the new employer to a potential claim against them if they're inducing the breaches of the employment contract. A claim for damages against a new employer that's typically got much deeper pockets than your average employee is going to be a lot more attractive. So a key point to note at this stage is you're going to want to act quickly and decisively. So that's finding out as much information as possible as to how the business is going to be affected by the loss of the confidential information. And that's critical in determining whether it's going to be in the business's interests to actually make an application for an injunction. By engaging forensic experts and legal advisors at the early stages, that's going to place the employer in the best position as possible to make an accurate assessment on that point. So if those steps don't resolve the matter, if the undertakings aren't given, then an application to the court can be made to seek an interim injunction. And if you successfully obtain that, the court can order the employee to deliver up and destroy confidential information, preserve any documents that they've got, be subject to a search order, which John will touch on shortly. They can also require the employee to restrain them from specific actions or uses of that confidential information. And then they can also grant something called a springboard injunction, where that limits or removes the advantage that the employee may have gained from using that confidential information already. In order to successfully obtain an interim injunction, the employer is going to have to meet a three-part test. So firstly, you're going to have to establish that there is a serious issue to be tried. The court's then going to consider the adequacy of damages. So firstly, they're going to look at, will damages be an adequate remedy if the employer succeeds at trial? If so, then an interim injunctive relief is not normally going to be granted. If damages would not be an adequate remedy, then the employer's cross undertaking and damages provide adequate protection for the employee or the third party new employer. And then finally, the court is going to consider the balance of convenience test, in which the court's going to consider the particular factual circumstances in which the injunction is being sought, and where such factors are evenly balanced, the court's then going to look to preserve the status quo as far as possible when the employee's obligations were being observed. So whilst being able to meet that test is going to be critical in obtaining an injunction, there's some initial points as well at this stage that you're going to want to bear in mind. Firstly, an interim injunction is only ever going to hold the ring until there's a final trial of the underlying claim. The court can list a final trial in a few short months after that initial hearing to make a decision on that underlying claim. So you need to be prepared to return to court soon after. And this can mean there's a lot of work to do for the employer in order to meet that quick turnaround time and be prepared for that final trial. So that's why it's important to have that initial investigation up front and collecting as much data as possible on the breaches that have taken place. At the interim injunction hearing, there's typically not any live evidence. So that will mean there's not going to be any witnesses giving live oral evidence, but the court's going to look to the written witness evidence that's before it and the documents that are available at the time. Again, that's why it's so important to undertake an effective investigation at the outset so that you can present your best evidence to the court up front at the injunction hearing. And then finally, as I've sort of just mentioned, a claimant in an injunctive action is going to be required to provide a cross undertaking and damages. So this would be an undertaking to compensate the defendant if later it's decided that the order for the interim injunction should not have been awarded. And depending on the circumstances, the undertaking and damages could be quite substantial. So you're going to require legal advice about the implications of a cross undertaking, and you'll want to conduct a cost benefit analysis in relation to the taking an injunctive action overall.
Thank you, Jack. John, you will be the one that is executing the order from a practical perspective. I always involve the forensic team in drafting the relevant order. What types of things would you be feeding into the lawyers drafting the order?
Well, before I answer that, I think I need to stress that me and my team, we're not legal advisors. We obviously work a lot in legal cases, but we have no legal training. What we do know about, of course, is the IT side, the data side. And so we would absolutely be involved in certainly reviewing the technical aspects of a draft order to make sure that the order as drafted does allow us to conduct a proper investigation. Sometimes the wording by accident really doesn't allow us the amount of proper freedom. I'll come on to some limitations to that in a second, but it doesn't allow us the proper freedom to fully investigate the device that's been seized. And I can give an example. Let's just say one of the items that we are searching for is a spreadsheet called confidential. So confidential XLSX. And that would be used as a keyword typically. And we would find potentially the document itself. We might find links to that document that's shown what's happened to it. But very often there's lots of other information on that computer that doesn't contain the word confidential.xlsx, but nevertheless tells us about activities that have happened to that file. And so if the order says you are only allowed to look at files that contain that word, then that restricts us, I think, unfairly in terms of the investigation that we can do. So it's important to look at the order as it's drafted on a technical expert level to see whether or not it does actually achieve what you're hoping to achieve. And I don't think a court would object if you made the orders in such a way that it would allow that sort of inquiry and investigation about a document without actually containing the name of that particular document. And lastly, one of the major issues that we have, particularly when dealing with information and data that's come from the result of a delivery up order, is for want of a better word, the contamination of the employer's information and that's owned by the user, and is very often sensitive in nature, things like family photographs, bank details, all that type of thing. Rebecca touched on the acceptable use policy, so that can easily apply with the information derived from the workplace, but it's obviously a lot more of an issue with information that has come from, for example, somebody's home address. And the ways to deal with that make the resulting investigation quite complex. So, for example, one of the ways that we would deal with it would be to segregate all of the information. We would then review the information that we think is relevant and present that to the employee and his or her legal team for their review before any decision is made to hand it over to, in effect, our clients, the employer and their legal team. And the whole business of triaging that sensitive data makes the process, or can make the process, quite unwieldy and more expensive than otherwise might be envisioned. However, it's right and proper that it happens because nobody wants their information about their personal life and their family in a legal case that has absolutely nothing to do with it. So we're very alive to those sort of sensitivities.
Thank you, John. That's very helpful. I've had a number of questions, but in regard to time, I'll just take one of these and then we can answer the rest directly to the individuals. So the query was whether or not the same principles we've been discussing applies to consultants. And the answer is yes, same principles do apply to consultants, and they may have both express obligations in their contracts, but also implied obligations of confidence. So thank you, Rebecca, Jack, and John. A lot of ground has been covered today, and we could talk about these issues for much longer. We will follow this seminar up with a cheat sheet of key takeaways and considerations of the points we've been discussing today. If any of you have any questions, as I said, please email ourselves and John, and we'd be happy to have a discussion with you about them. So thank you, everyone.